The Honorable, the Supreme Court.
Good morning again. Thank you very much. Please be seated. Thank you. Please call the case.
Good morning, Your Honors. The matter before the court this morning is a case entitled State of Vermont v. Jason Meade, case number 23 AP 140. Representing the appellant, Jason Meade, is attorney Brianna Hauser. Seated at counsel table with attorney Hauser is attorney Rebecca Turner. Representing the appellee, State of Vermont, is attorney Evan Meade.
Thanks very much. Come on up. Please introduce yourself and identify your client before you proceed, if you would.
Good morning, Your Honor, and may it please the court, Brianna Hauser on behalf of appellant Jason Meade.
Thank you.
Mr. Meade is challenging the trial court's modification of his probation condition 32 because the state did not establish that there was a significant change in Mr. Meade's circumstances to justify the modification as required by this court in State v. Day. This is not a challenge to the Department of Corrections authority to require programming as a condition of furlough.
So, Ms. Hauser, I'm going to interrupt you immediately, and my apologies for that, because you compared this to Day. So, in Day, the lower court, sought to impose far more restrictive conditions of probation after the sentencing. Isn't that different than this case when one program was imposed as a condition of probation under 32, the cognitive help me here.
Cognitive
Self-change thing, okay. Was it replaced by the risk reduction program? So that's tell me why that's a significant restriction.
So in Day, what the probation officer sought to do was to impose a program that had been developed after the probationer was sentenced there. And the court acknowledged that the modification was harsher or more restrictive. In this case, the original condition required Mr. Meade to participate in the cognitive self-change program, which the state has admitted is a different program from the risk reduction program here.
But it replaced the other, right? The first program was withdrawn, and this replaced it.
Yes, that's true.
But we don't know the difference in the two programs. Well, the fact that one replaced the other doesn't have anything to do with whether one's harsher than the other.
Exactly, Your Honor. And so that's our argument, is that there was nothing in the record that could support any finding by the trial court that risk reduction program was not in fact more onerous for Mr. Meade as compared to the cognitive self-change program.
Was there evidence in the record that it was more onerous?
So the evidence, what we know is that the requirement for risk reduction programming would impose 6 to 9 months of incarcerative programming for Mr. Meade. But there's nothing in the record about how that compares to the time of the cognitive self-change program or any other requirements for the cognitive self-change.
But that 6 to 9 months was if it was imposed as a condition of his release, as opposed to this being a probation condition, right? I mean, the probation condition didn't make him stay in jail for 6 to 9 months. It was DOC saying, we don't care what the probation condition says, we're still going to make him do it in order to be released.
Well, I think that goes to an issue of notice in this case, that it's how the trial court framed this was that it was viewing the probation condition for risk reduction programming as coextensive with the furlough requirement.
And risk reduction program requires incarceration. That's done in-house at the window. So when the person's got a release date of, say, 9 months away, then the department applies the risk reduction programming so that the person, when they release, that the risks are minimized. And in self-care or the The,
Cognitive
Scott,
self-change.
thank you.
I think we all
Um,
need that.
You don't need to be incarcerated for that, is that correct?
Well, there's nothing in the record about what was required under the cognitive self-change program. The state's witnesses said that there were differences between the two programs, but that neither of the state's witnesses knew what those differences were. So there's nothing for the trial court to have determined that risk reduction programming wouldn't in fact be more onerous than the cognitive self-change program.
Didn't the trial court here say the programs were synonymous, though with unspecified differences?
Yes.
What does that mean?
So one of the state's witnesses testified that from the Department of Corrections perspective, both of these programs fulfilled the same function for the Department of Corrections, and that was that they were used as the violent offenders program for incarcerated people. That's regardless of whether any probation condition applies. So the department has the authority to require that incarcerated folks participate in certain programming, whether or not they have a probation condition that requires it.
And you're not challenging the ability of the department to order this as a furlough condition.
Correct, we're not challenging that. What we're challenging is the programming being imposed as a condition of probation on top of the requirement already that Mr. Meade participate in this programming as a condition of furlough.
So we've used the words more onerous a couple of times. What does the law say about parity between programs? From whose point of view is a determination under the law to be made as to whether or not one program is equal to another?
So under Day, I think it has to be from the probationer's perspective. What the court said there was that if a modification was going to be harsher or more restrictive, then there has to be a significant change in the probationer's circumstances. And it's fundamental to sentencing that it has to be individualized to a probationer's rehabilitative needs. So if a new probation condition is being imposed, it has to be related to the probationer.
So even if it's harsher, if there has been no change in the probationer's conduct, it's not appropriate?
Under Day, no. That's the standard that this court established in Day.
But isn't the elimination of the program and replaced by another, isn't that a change of circumstances? That because technically then your client would never be able to complete either the, he would either be violated if he doesn't do the program, if it becomes a probation condition. Alternatively, if he decides he doesn't want to do it while he's still incarcerated, he'll just max out. And then it becomes a probation condition that he has to complete the program. So I'm seeing that as a change of circumstances for your client to be able to be released from prison, or alternatively to avoid a violation of probation.
So in this case, Mr. Meade hasn't reached that point. The state has the authority, because of the structure of Mr. Meade's sentence, the state has the authority right now to keep him incarcerated up to his maximum incarcerative term on the basis of the furlough condition alone. So even if this court were to reverse and vacate the trial court's order, he would still be subject to that condition. And again, we're not challenging that.
Okay.
But
the change in conditions talked about in Day is something in the probationer's behavior. It's not the department's decision to change one program to the other. That's not the change that Day's talking about.
exactly, and that was a clear distinction that the court made in Day, was that the basis for that modification was the department's change in programming, and this court said that wasn't enough. You needed to establish that there was some change in the probationer's behavior or circumstances to justify a modification.
I read Day as saying there needs to be a change of circumstances. And then there was a catch-all specific to that defendant, because the conditions that were imposed in Day were all behaviorally associated. a curfew, urinalysis or testing, treatment. And it said that the court erred in that case by imposing conditions when he didn't change his behavior, meaning that those conditions were directed towards behavior and he had not changed his behavior. Do you see that?
Well, I think it still doesn't make Day any different from this case because we don't know what the specific requirements were under the risk reduction program that Mr. Meade was going to be subject to. And so.
But it has
the
nothing to
standard-
do with a change in his behavior if DOC is requiring him to do a program that is going to assist him when he gets out. It does. How does that have to do with his behavior in the facility?
If I understand Your Honor's question, what the standard established in Day is that based on the contract-like nature of probation conditions, the court cannot modify any probation condition unless you have the probationer's consent or a change in circumstances. In addition, if the modification is going to be harsher or more restrictive, there has to be a significant change in the probationer's circumstances. And that's because where a modified condition is going to be harsher or more restrictive, it implicates a probationer's right to due process. And so for that reason, there has to be that additional standard, that additional burden that the state has to meet if it wants to impose a harsher or more restrictive.
Ms. Hauser, is there any evidence at all to say that this risk reduction programming available outside the facility?
So the state's witnesses testified that Mr. Meade could be subject to a violation of probation, both while he was incarcerated and after he is released on probation. So we don't really know what is being required of Mr. Meade when he's fulfilled that condition. And again, I think this goes to notice that it's not clear that even if Mr. Meade were to do the risk reduction programming while he's incarcerated as a condition of furlough, that he couldn't then be again required to do it on the outside when he's on probation.
We have language here in this case and in others that talk about probation conditions being a contract. Would this matter? Would the outcome here be different in your view if this had not been an agreed upon probationary sentence and term, but instead had been imposed by the judge? So I guess what I'm asking is, doesn't that take you out of the contractual realm if someone is sentenced and objects to all the probation conditions and the judge says, I don't care, we're imposing?
No, I don't think it makes any difference because it's still the probation conditions that are imposed by the sentencing court. The probationer is entitled to rely on what those conditions are.
Right.
And it's a contract between the court and the probationer. So
Well, that's, I guess my point is in some instances, it's not a contract. It's imposed. And that would be, if it's a contract, it's the ultimate adhesion contract, is it not? Where the defendant says, I'm not guilty, I don't want to be sentenced, but you're being sentenced and here are the probationary terms. That's no contract.
Well, I think either way, what a court would have to do under Day if it's seeking to impose a harsher or more restrictive condition as compared to that initial condition, it would have to establish that there's a significant change in the probationer circumstances, and that's related to due process. Unless there are any questions, I would reserve the remaining time.
All right, thanks very much. We'll hear from counsel for the appellee, please. Introduce yourself and identify your client and proceed.
Good morning, and may it please the court. My name is Evan Meade, and I represent the state of Vermont.
Thank you.
I'm or at least I plan on spending the majority of my argument talking about whether or not there was a justification for modifying condition 32. But I would first like to just very briefly address a relatively discrete point that has sort of come to head by virtue of appellant's reply brief. and that has to do with collateral challenges to probation conditions. In the state's brief, the state argues that some of defendants' arguments are impermissible collateral challenges. Those include things like the alleged vagueness of condition 32 and that conditions 5 and K overdelegate authority to DOC. In his reply brief, appellant argues that the impermissible collateral challenge doctrine basically only applies in the probation violation context, and the state adamantly disagrees with that proposition, at least in this case. All of those vagueness and overdelegation arguments that appellant is raising now would have applied equally to all of those conditions when they were originally opposed. Appellant could have appealed those conditions, and he did not, and he's trying to now effectively appeal them. He should be especially precluded from doing so with regard to conditions 5 and K because they were not even amended. So under appellant's theory, motion to amend one probation condition would be grounds for challenging any probation condition. With that point briefly covered, I'd like to turn now to whether or not the court had a sufficient basis for modifying condition 32.
So Attorney Meade, I'm going to interrupt you like I did Attorney Hauser before you begin, because something has been troubling me is the fact that probation filed the motion to modify condition 32 to replace the cognitive self-change program with the risk reduction program. And doesn't that serve as an admission that the plain language of the condition did not permit the trial court, and I'm probably saying this wrong, the trial court ruled that the plain language of the condition permitted her to make that substitution. But doesn't the filing of the motion itself serve as an admission that it doesn't fit the plain language, therefore you have to modify it to impose the condition?
No, in this particular case, based really on the facts of this case, the answer to your question is no. And the state spent a significant amount of time in its statement of facts summarizing some of the dialogue that occurred between various DOC representatives and appellant. And what those facts establish is that DOC attempted on multiple times to get him to enroll in RRP. He sort of wavered in his interest in engaging in that programming. But there was one conversation, it was either in June or October, I believe there was 2 in-person conversations. And during that conversation, the appellant expressed an interest in engaging in RRP. And the testimony from DOC was that they were discussing the handwritten timeframes on his probation warrant. And I believe the phrase was something to the effect of he wanted a probation warrant that stated exactly what he was expected to do. And so I think that the evidence would support the conclusion that what DOC was trying to do was get the appellant what, at least at the time, he was claiming he wanted, was just a crystal clear probation warrant. That doesn't mean that DOC was acknowledging that it couldn't have relied on either condition 32, 5, or K to require the same programming, as, for example, it did in the Sanborn and Coleman cases, which are discussed at length in the state's brief. It's just, yes.
But isn't the condition that you shall participate in the cognitive self-change program crystal clear? It's the cognitive self-change program, not some other program, not a replacement, not something that's like it. It's that one. So doesn't it need a modification if you're going to make the probationer comply?
I think that the answer to that is no under Sanborn and Coleman, and also, as a matter of fact, under Day. I mean, I'm not going to pretend as though it wouldn't have been better if condition 32 said probationer shall complete DOC's violent offender programming. I'm also not going to stand here and argue that it wouldn't have been better if DOC had a witness that could provide very detailed explanations of cognitive self-change versus risk reduction programming. That additional information would have been fantastic in this case. But we don't review whether or not the question isn't, are there things that we wish existed that didn't exist? The question is there absence reversible error? And the state's position is no. And turning specifically to the Day case, that case is significantly different from this one, despite appellant's assertions to the contrary. Most specifically, in that case, What happened was the probations were modified to impose a programming requirement when there was no previous programming requirement. That's significantly different from this case in which there was a programming requirement. DOC updated that programming pursuant to its statutory powers and responsibilities, and then required appellants to complete the updated programming.
But when the department decides that they're going to change programs for whatever reason, is it too much to expect when you have a specific program called out in the probation conditions? Is it too much to expect the department to show up with somebody who knows the difference between the two programs and can explain it to the judge?
Again, I'm not going to pretend that that wouldn't have been ideal testimony to have in this case, but the state's position is it's not reversible error. What we did have was DOC employees who showed up and explained in general terms the process for updating the programming, which again was consistent with DOC's statutory powers and responsibilities. And then they described that the programs, there was 3 different terms that were used. The first was synonymous, the second was nearly identical, and the third was equivalent.
Right.
Now,
And then when they would drill down on that, they had no information.
That's right. They couldn't provide any more specific detail. However, in probation modification proceedings, it's the trial court judge who is the trier of fact. And as the trier of fact, they are the judge of witness credibility. Appellant pointed out that these individuals did not have more detail, and the trial court judge could have, but did not conclude that their lack of knowledge about the additional details was a reason not to believe them that these programs were synonymous, nearly identical, and equivalent.
So does it mean they have to have some basis to say that? The judge can't just believe it because they say it.
Well,
there's got to be something behind it.
The judge was able to take their qualifications, experience, appearance, and demeanor into consideration, and ultimately reach the conclusion that this program was not more onerous than RRP, was not more onerous than cognitive self-change.
So, Mr. Meade, this was a split sentence. It was a split sentence where when he was eligible, he was going to be released from prison and subject to probation.
Not.
Well, that was the
not
original
completely
contemplation.
accurate.
And that would be a split sentence, so, correct? He gets released, he's still on probation for a certain period of time, evaluates any of the conditions, he could serve out the rest of his sentence.
That's actually not how this sentence was structured, Your Honor. This is a very unique split sentence because the split was sort of split. It's very odd.
I was
Split on.
So
it was split on the split, but anyway,
so it would be released on furlough, and then upon completion of furlough would be released on probation. So I think it was at year 14, he would have been eligible for release on furlough. And then at year 20, he would have been eligible for release on probation.
And probation, one of the conditions of his probation on the split was that he whether he participated in cognitive self-change.
Yes, that was a condition of his probation, and also it's a requirement of his furlough.
You argue in your brief that the probation issue is moot because DOC would have required him before release on furlough to participate in this program anyway. But based on what we just heard, isn't it not moot because he is at some point going to be on probation?
Well, I don't argue that it's moot. I argue that it's harmless error. And the reason why I do that is because appellant's due process argument is that completing this new programming is effectively beyond his control because he will not have enough time to do it prior to his minimum release. Therefore, he will be held past his minimum release, and that is a due process violation. The state's argument is first, well, that's his own fault because he could have completed this as part of furlough or probation, take the pick at any point in time and have been brought back. The state's second argument is if your principal complaint is that you're not going to be released at your minimum, well, that wasn't going to happen anyway because you have to do this as part of furlough. So if the test under harmless error is whether or not someone's substantive rights have been negatively impacted, that delay, the answer is no, not in that case, not in this case, because the delay in his release is not DOC's fault, it's his fault, and he would have been required to do this as part of furlough. It's a bit of a separate issue, what might happen after his maximum sentence if he's released on probation and still hasn't completed the programming. I know this fact is not in the record, and the court's free to disregard it if it would like. But the update that I last received in December was that appellant is scheduled to begin RRP sometime this month. He might have already done so,
Mr.
I'm not
Meade,
sure.
was this particular issue about whether the condition was more onerous argued below at the probation modification hearing?
Oh, I think absolutely as a result of the court's ruling. And that brings me to the second reason why Day is distinguishable.
What do you mean as a result of the court's ruling? I meant, was the argument made below that court, you need to find a change in circumstances because this program is more onerous. Was that argued below?
Oh, I think appellant preserved that argument, yes. And I think, when I was referring to the trial court's order, I think the court responded to that argument, and in doing so, identified the second reason why Day is distinguishable, and that's because Day's holding is significantly narrower than I think appellant would like this court to conclude. The issue in Day, or the holding in Day, was that there has to be a significant change in the probationer's circumstances prior to imposing a harsher or more restrictive condition. The Day decision really did not address what type of standard needs to be met when a change in a condition will not be harsher or more restrictive. The trial court very clearly in its decision determined that Day is simply inapplicable because that specific holding does not apply in this case as a result of the court's factual finding based on its judgment of the credibility of the witnesses that amending condition 32 did not result in a harsher or more restrictive condition.
But there's some language in Day that's a little broader than what you've just recounted. It says changing the terms of probation without either the probationer's consent or a change in circumstances betrays the justifiable expectation that the agreement will be honored.
Yes, but I think that if you read that language in the context of the court's entire decision, and I just tried to pull it up in my brief, and it's a passive citation. I gave it quite a bit of treatment. But there's other language. My recollection, hope it's correct, in the last paragraph was the final word was, if you're going to require something more onerous of a defendant, there needs to be a significant change of circumstances. The parties did not litigate in that case. What if the change is not more onerous? That simply was not an issue in this particular case. I'd also like to, just before reserving, I'd also like to address Chief Justice Reiber's question about what the law says about the parity amongst programming. And I really do think that the closest guidance that this court has provided to date is the Sanborn and Coleman cases, particularly Sanborn, because in that case, there was two probation conditions. One was a general treatment condition, similar to, for example, what we have in conditions 5 and K. And then the second one was a program-specific condition that the probationer completes Franklin County mental health programming. And this court upheld the use of the general treatment condition to require treatment similar to the program treatment specific once the Franklin County mental health program was no longer allowed. And in Coleman, it's a very similar fact pattern. One was a general treatment condition, and one was a condition that required the probationer to follow through with his existing provider. The provider did not provide the treatment that was recommended, and this court upheld the use of a general probation condition to require it. But I think at their heart, what Sanborn especially recognizes is that the DOC's programming authority can be used to require the appellant to participate in equivalent programming when the programming contemplated at the time of sentencing, which may have occurred a decade earlier, is no longer available. And I'd like to I see I'm out of time, but thank you very much for your time.
Mr. Chief Justice, may I ask one more?
Please, yeah.
Attorney Meade, thank you. So Attorney Meade, you talked about the trial court judging the credibility of the witnesses, coming to the conclusion that it was a program that substituted for, RRP substituted for CSC, now that it was no longer in existence. The judge in her findings, the judge in her conclusion simply stated that she finds that the program is relevant to the defendant's charge of conviction. So therefore, I can impose the condition. She didn't make any particular findings. Is she relying just on the testimony of the office of the probation officers? Because she didn't articulate that either.
Well, I think the trial court's obligated to base its factual findings and legal conclusions on the evidence presented, which in this case was the DOC witness testimony. But I think what the trial court properly recognized is implicit in that conclusion is the recognition that what DOC's motion to modify is consistent with the most pertinent one of its statutory responsibilities, which requires it to establish a program for each inmate upon his or her commitment to the facility. And here's the important part: to review the program with each inmate at regular intervals and to effect necessary and desirable changes in the inmate's program of treatment.
But that's not probation. That's not probation. That's incarceration.
It doesn't specify, and in this particular case, appellant was incarcerated. And my understanding of the record is after he serves his 14 years, he will be on dual status, furlough and probation.
All right.
So theoretically, he could be facing a probation violation while still incarcerated.
Thank you, Mr. Meade. Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 53 seconds remaining, Your Honor.
Counsel.
Thank you, Your Honor. One point I'd like to address here first is on the issue of the burden of establishing that a modification will be harsher or more onerous. The state conceded in its brief that if the modification here were requiring Mr. Meade to participate in some sort of program that was significantly more onerous, there would be an issue here. And it's the state's burden to establish that it's entitled to a modification. The state hasn't disputed that. And particularly in this case, when the state's witnesses didn't even have any information about the differences between the requirements of the two programs, Mr. Meade certainly can't have been expected to know whether one program was going to be more onerous than the other. The second point I'd like to make is on the issue that the state raises around collateral challenges. Mr. Meade couldn't have challenged.
Water?
I have some.
Have you got some?
Yeah. Mr. Meade couldn't have challenged the probation condition as modified here in his direct appeal because he didn't have that probation condition imposed until after this modification. So he's not precluded from raising these challenges to the language of this probation condition as modified. And this court has made clear that a probationer is not precluded from raising constitutional challenges in the context of a motion to modify probation conditions.
I heard Mr. Meade say he was making that argument with respect to other probation conditions, that they were collateral challenges, not condition 32.
Well, even to the extent that he was arguing about other conditions, no other condition was brought before the court in this case, and Mr. Meade certainly can't be said to have foregone a challenge to a probation condition that wasn't before the court. And I see my time is up.
Okay, thank you very much. Please call a conclusion.
The next hearing for the court is scheduled for